This courtroom hearing starts off looking like a routine speeding ticket case, but within seconds, it becomes clear this is anything but normal. The defendant, Mr. Robinson, steps forward and immediately challenges the court's authority, insisting he's making a special appearance and questioning whether the judge even has jurisdiction over him. While he strongly denies being a sovereign citizen, everything he says sounds eerily familiar to those arguments often seen in viral courtroom clips. Mr. Robinson claims speeding is a victimless crime and demands proof of a hurt person, arguing that without an injured victim, the case should be dismissed. The judge listens patiently as the defendant speaks in circles, citing technical language and filing documents he believes will override the law. But the calm tone of the courtroom begins to shift as the judge methodically breaks down each argument, explaining that traffic laws exist to protect the public, and that the state itself is the victim when those laws are broken. As the hearing continues, tension builds. The judge points out procedural mistakes, including discovery requests that were never properly filed or served. Mr. Robinson grows visibly frustrated, making sarcastic remarks that push the limits of courtroom decorum. At one point, the judge issues a clear warning about contempt, signaling that these arguments are wearing thin. The prosecution steps in, citing established case law that makes it clear, sovereign citizen beliefs have no standing in American courts. One by one, Mr. Robinson's claims collapse. In the end, the judge delivers a straightforward verdict: guilty of speeding at 92 miles per hour in a 75 zone, along with a fine and court costs. This hearing serves as a powerful reminder that no matter how confidently someone argues against the system, the law still applies. And the courtroom is where those theories meet reality.
Mr. Robinson, are you here?
I am here representing the name, ma'am.
All right, you need to start your video, please. And you are, is it Tremaine or Tremaine?
The name I'm representing is Tremaine.
Tremaine. And how do you pronounce your middle name?
J.
Tremaine J. Robinson.
On and for the record, ma'am, I want to say that I want to give notice to reserve all my rights and inform the court that I'm not here to testify or plead. I'm here to make a special appearance to challenge the jurisdiction only.
All right, anything else?
Yes, I would like to see evidence of a charging instrument.
Were you not given a copy of the ticket issued by Trooper Collins?
The charging instrument that I am referring to is a sworn affidavit of the client, of the person that I've hurt.
Now, this is a speeding ticket alleging that you did on March 27, 2023 at 8:48 a.m. operate a motor vehicle in Butler County, Kansas at the speed of 92 miles per hour when the posted maximum speed limit was 75 miles per hour. So this would have been out on the Kansas Turnpike, Highway I-35. Now, what else were you wanting to know, sir, as the allegations against you?
I would like to see evidence of the affidavit of the people that I've hurt. This is a victimless crime. If there's no one that I...
Well, the victim would be the state of Kansas in that you violated the laws enacted to protect the people of the state of Kansas. But this is not the type of crime which would require or have individual names listed. So your next point, if any?
My next point is, as I stated, ma'am, I'm not here to testify. I'm not here to plead. I would like to see the affidavit with 2 signatures for the person that I've hurt. If I didn't hurt anybody, there's no crime.
All right, well, I'm going to proceed. The subpoena was issued July 7, 2023 for Trooper Collins. Then on July 31st came a correspondence from the defendant as referred to by Mr. Regier herein. Looks like it's about 7 typed pages, and as counsel said, it's entitled Challenge for Jurisdiction and addressed to Butler County District Court Clerk, Butler County District Court Clerk, Office of the Attorney General Derek Schmidt. And it mentions subtitles under the following case law. I request case 2023 TR 1193 be dismissed. Pretty much standard language that is used by folks who call themselves or are considered sovereign citizens. Quote, it is on this date, July 27, 2023, I, Tremaine J. Robinson, it's Tremaine-J, Robinson, in the county of the Seminole of the state of Florida and a zip code, a natural man, attorney in fact, as a living human being who's the beneficiary of Tremaine J. Robinson trademark. Swear that the information in my sworn statement is truthful to the best of my knowledge and understanding. I, Tremaine J. Robinson, beneficiary of Tremaine J. Robinson, revoke my signature on any and all pages of any and all tickets, summonses, contracts, and or agreements signed by the side of the road in the state of Kansas by Officer Collins K. And so here we are. Now, Mr. Robinson, normally I would be upset that you filed what appears to be in part a motion for discovery and you didn't get that. However, you did not address that document to anybody but Butler County District Court Clerk Traffic Court, Butler County District Court Traffic Court. You sent one to a P.O. box in Topeka, and then you sent a copy of it to the Attorney General. But you did not send it to the Butler County Attorney. Therefore, he did not know you were trying to get discovery.
Ma'am, I do have a tracking number that says it was delivered at the Butler Attorney.
Okay, well, that's not on file. What you want to present that at this time?
Yeah, someone signed for it yesterday.
This document that I'm giving the benefit of, it's a multi-subject document, but this document filed by the defendant that I'm giving the benefit of including what he offers as a motion for discovery was not filed with the clerk until July 31st. So that was after the statutorily required 21 days. And then it was not filed upon the prosecutor who would have, or the witness who would have held any evidence, but rather again on Butler County Clerk in Topeka, Kansas, that to my knowledge doesn't exist, the Butler County Clerk in El Dorado, and Attorney General then Derek Schmidt in Topeka. And that's if it was served, if I take the defendant's benefit of the doubt, that it was saying it was served sometime yesterday before today's 1:30 trial, the court has to decide if that later time was reasonable, and I do not find that it was reasonably served on the county attorney. I am at this point going to say that any last minute motion for discovery is denied and we are prepared to go to trial. Now I've lost you, Mr. Robinson. Are you still somewhere available?
No.
What are you doing there with your computer?
Right now, I was looking for a document, but no, I am not available for trial.
Proceed with trial. So please put yourself back in front of the camera. Follow the court's order or you could be found in contempt. I don't want to do that. Thank you, sir.
Your Honor, in that particular case involved a sovereign citizen where the court noted in the memorandum opinion.
Objection, hearsay. Objection, hearsay.
Case law is not considered hearsay or.
I'm not a sovereign citizen.
All right, he's not a sovereign citizen. Go ahead, Mr. Regier.
Yes, Your Honor. In that case, the Kansas Court of Appeals noted, quote, the defendant thinks the law does not apply to him. He avows that he, unlike other citizens, is sovereign and immune from prosecution. The court went on to address the issue of venue, which the court noted that, quote, venue is generally proper in the county where the crime was committed. I will address that momentarily, as well as referring to KSA 22-2602. Additionally, and perhaps most relevant to this court, the defendant in that case, quote, complains that his objections to the trial court's jurisdiction to prosecute him arise from the claim that he is a sovereign citizen. This is not the first appellate court to deal with such a claim. Another panel of this court used analysis of federal case law to reject a similar claim. And then quoting from Seventh Circuit and Eighth Circuit cases, quote, an individual's belief that his status as a sovereign citizen puts him beyond the jurisdiction of the courts has no conceivable validity in American law, regardless of an individual's claimed status of descent, be it as a sovereign citizen, a secured party creditor, or a flesh and blood human being. That person is not beyond the jurisdiction of the courts. These theories should be rejected summarily, however they are presented. And with that, I would respectfully call my first witness to the stand.
All right. I do find that this court has jurisdiction and venue to proceed, and the arguments made by the defendant in the 7-page document referred to previously are summarily dismissed.
Ultimately, write the defendant a citation for speeding?
Yes, I did.
Or an annual redirect? No further questions.
All right, Mr. Robinson, this is your opportunity to cross-examine the trooper. You can question him about his testimony. It's not quite time for you to give your own testimony, so these addresses to the trooper have to be in the form of question. You don't have to question him, but you can. Would you like to?
No.
All right. Mr. Regier, any further evidence?
None from the state, Your Honor.
Okay. The state rests then, Mr. Regier?
The state does so rest, Your Honor.
Mr. Robinson, the state rests. They have presented all the evidence they intend to. Would you like to present any evidence? Again, you don't have to. Your silence will not be used as a sign of guilt. But if you'd like the court to consider your position, I'd be happy to do so.
I don't understand.
Well, do you want to tell the court your version of what happened?
No.
All right. You don't wish to present any evidence then. Am I understanding you correctly?
The evidence that I tried to present, you won't give due process.
Okay. But do you want to give any testimony about the events leading up to this ticket, March 27, 2023?
No.
All right. Well, I will find the defendant guilty of speeding 92 and a 75. The scheduled fine is $87. Court costs are $108. The total due will be $195. Sir, you do have the right to appeal this proceeding. You can appeal it to the Kansas Court of Appeals. You have up to 14 days to file that notice of appeal. Your appeal bond will be in cash, the same as what your court costs and fines are. That's $195. Can you have this paid, this fine and cost paid in 14 days, or do you need some time?
This courtroom hearing begins like countless others across the country, quiet, procedural, and seemingly routine. A simple speeding ticket is on the docket, and the judge is prepared to move efficiently through the case. But the moment Mr. Robinson begins speaking, it becomes clear that this hearing is headed in a very different direction. What should have been a brief exchange quickly turns into a drawn-out confrontation between established law and a man determined to argue that the law does not apply to him. Mr. Robinson opens by announcing that he is making a special appearance, immediately signaling the tone of the hearing. He insists that he is not subject to the court's jurisdiction and demands proof that the court has authority over him as an individual. Although he repeatedly denies being a sovereign citizen, his language and arguments mirror the same pseudo-legal theories often seen in viral courtroom videos. He speaks confidently, as though reciting from a script he believes carries legal power, asserting that the case must be dismissed before it can even begin. One of Mr. Robinson's first claims centers on the idea that speeding is a victimless crime. He repeatedly asks the court to identify the injured party and demands an affidavit from a person who was supposedly harmed by his actions. In his view, without a named victim who suffered direct damage, the state has no standing to bring the case. He frames his argument as logical and constitutional, suggesting that the absence of a victim automatically invalidates the charge. The judge listens carefully, allowing Mr. Robinson to speak at length. Rather than interrupting or escalating the situation, the judge responds calmly, explaining that traffic laws are enacted by the state to protect the safety of the public. When someone violates those laws, the state itself becomes the victim because the conduct threatens public welfare. The judge makes it clear that not all crimes require a specific individual to be harmed, and that the legal system does not operate on the narrow definition Mr. Robinson is trying to impose. As the hearing progresses, Mr. Robinson continues to challenge nearly every aspect of the process. He questions the legitimacy of the charges, the authority of the court, and even the legal definitions being used against him. He references documents he has prepared, including a lengthy written filing that he believes undermines the prosecution's case. However, when the judge reviews the situation, it becomes evident that the document was never properly filed or served to the county attorney's office in accordance with procedural rules. The judge explains that discovery requests and motions must follow specific legal procedures. They must be submitted in advance and properly delivered to the opposing party. Simply bringing paperwork to court and referencing it verbally does not meet those requirements. Mr. Robinson appears frustrated by this explanation, insisting that his paperwork should still be considered valid. He argues that formality should not outweigh substance, but the judge reminds him that procedure is the foundation of due process. Tension begins to rise as Mr. Robinson grows more combative. His tone shifts from confident to defensive, and his comments become increasingly sarcastic. At several points, he interrupts the judge or attempts to redirect the conversation back to his jurisdictional arguments. The judge warns him to remain respectful and focused, emphasizing that courtroom decorum is not optional. When Mr. Robinson continues to make snide remarks, the judge issues a clear warning about contempt of court. The prosecution then steps in to address the broader legal theories being presented. The prosecutor cites established case law that has consistently rejected sovereign citizen-style arguments. Courts across the country have ruled time and again that claims of personal sovereignty, special appearances, and immunity from statutory law have no legal basis. The prosecutor explains that these arguments are not new, and they have been thoroughly addressed and dismissed by higher courts. Despite this, Mr. Robinson persists. He insists that he is not refusing to comply with the law, but merely asking the court to prove its authority. He frames himself as someone seeking clarity rather than confrontation, though his repeated interruptions and dismissive comments suggest otherwise. The judge responds firmly, stating that the court's jurisdiction is well established and does not require the defendant's consent to exist. As the discussion continues, the judge methodically dismantles each of Mr. Robinson's claims. The judge explains that driving is a regulated activity, not an unrestricted right, and that by choosing to operate a vehicle on public roads, drivers agree to follow the laws governing those roads. Speed limits are not arbitrary suggestions, they are enforceable regulations designed to prevent accidents and save lives. Eventually, the court moves past the jurisdictional arguments and focuses on the facts of the case. The evidence shows that Mr. Robinson was traveling at 92 miles per hour in a 75 mile per hour zone. There is no dispute over the speed itself, only over whether the court has the authority to penalize it. The judge makes it clear that the facts support the charge and that the legal arguments raised by Mr. Robinson do not negate the violation. When the verdict is delivered, it is straightforward and unemotional. Mr. Robinson is found guilty of speeding. The judge imposes a modest fine along with standard court costs, emphasizing that the punishment reflects the nature of the offense rather than any personal feelings toward the defendant. The total amount is explained clearly, leaving no ambiguity about the consequences. Before concluding the hearing, the judge informs Mr. Robinson of his right to appeal the decision. He is told that he may appeal to the Kansas Court of Appeals within the specified time frame and that an appeal bond equal to the fine and court costs will be required. The judge's tone remains calm and professional, reinforcing the idea that the system provides legal avenues for disagreement, but not through disruptive courtroom tactics. As the hearing comes to an end, the contrast is striking. What began as a simple speeding case evolved into a lengthy demonstration of how sovereign citizen-style arguments fail under judicial scrutiny. The court remains steady, the law remains clear, and the outcome reinforces a familiar reality: confidence and rhetoric cannot override established legal authority. This case serves as yet another example of how pseudo-legal theories collide with real-world law. No matter how passionately they are argued, courts across the country continue to reject claims that attempt to place individuals above the rules designed to protect everyone. In the end, the courtroom does what it always does: it applies the law, dismisses unfounded arguments, and delivers a ruling grounded in legal reality.